Hi, I'm Diane McConaghy with the Diane McConaghy team at RE/MAX Select Realty. Today, I'm going to walk you through what's typically a 35-page real estate contract. I know that 35 pages can sound overwhelming, but don't worry. I'm going to break it down so that you know exactly what you're signing and why. You may not sign all 35 pages. Other times, depending on the situation, you might actually sign more than 35 pages. Every transaction is a little different. The goal of this video is to help you feel comfortable and confident that when that document hits your inbox via DocuSign, you're ready to go. All you need to do is click on the areas that we've marked for you, and then the system will automatically apply your initials, your signature, or the date. It's easy as that. So let's get started. The first page that you're going to see on any transaction is the MLS printout sheet. The reason that we send this to you is we want to make sure that this is the actual address that you have agreed to purchase. So this is just your acknowledgement that this is the address that you want to purchase. The next thing that you'll see is either a pre-approval letter from your lender or a proof of funds document that you need to provide to us if you're paying cash. The pre-approval letter will indicate how much you are eligible for or been pre-approved for. It should explain the type of loan and the term on the loan, and then if you need any seller assist, and then it should also include what your down payment's going to be. You don't need to sign this. This is just to let the listing agent know that we do have a pre-approval for you. The next largest document, it's typically 14 pages. It's the standard agreement for the sale of real estate. Your information or your name will have to go on this exactly the way that you want your name to appear on the deed. If you have a junior after your name or a senior or whatever you want, it has to appear here exactly how you want it on the deed. Your mailing address will go here, and then over here is just the seller's information. This is the property that you're purchasing. This is the city and the zip code, and then the municipality or the township. This would be Hopewell Township in Beaver County. We'll also list the school district, tax ID, or the parcel number. We get this directly from the tax records. The next section you don't need to worry about. This is just for the two realtors who are assisting with this transaction. In this case, this is my information, and it essentially says where my office is, and then phone number and my license number and my email, and that will tell the listing agent, who is Stephanie in this case. It'll tell her all of my information, and it'll show me what all Stephanie's information is as well. So you don't need to do anything in that area. Pennsylvania wants you to understand that there are dual or designated agencies. We would have talked this through with you previously when we had you sign the consumer notice. Once you get this document, all you're going to do is click down in this area, and you're just going to add your initials. The next page is the date of the agreement. Then it'll list the price that you are offering. And the next section is the hand money or earnest money. This is typically 1% of your purchase price, and it's held in an escrow account until the closing day. So if you owe, let's say, $10,000 in closing costs, this will be subtracted from that amount on closing day. And that's typically received within 5 days. Once the contract is signed by both parties, we're going to send you a link so that you can go ahead and wire transfer that money right away. This just says that RE/MAX Select Realty, in this case, since we're representing you as a buyer, it will be held in RE/MAX's escrow account. The next section talks about seller concessions. This is what they are paying for commissions to the buyer agent. Our agreement that you have signed with us says a 3.5%, so you would have to pay the difference of 3.5% and the 2.75. If you are looking for seller assistance, then that would go here. That's usually in the form of a dollar amount or a percentage. So if your lender said that you need at least $10,000 in seller assist, that would go here. Or if they say to go ahead and list a percentage, that 3%, 5%, 6%, whatever, that would just go here. In this case, this particular buyer did not need any seller assist. Then the settlement and possession that's the date that's going to go in here. We normally do 30 days. You need to set that date aside on your calendar, so don't plan anything for that day. The closing typically takes between 30 and 45 minutes, depending on whether it is a cash deal or a mortgage deal. This next section you don't need to worry about. It's just if we're prorating real estate taxes, the payment of transfer taxes are going to be divided equally between the buyer and the seller. So if you're purchasing in an area where it is a 2% transfer tax, you'll pay 1% and the seller will pay 1%, unless it's stated here that you're going to do something different. Possession will take place the day that you sign all the documents for closing. So once that deed is put in place, then you will be able to access the property and you will be able to move in that day of closing as well. If the seller has said that the property is subject to a lease or a rental agreement, we would have to specify in this area when the keys and the possession could actually go to the buyer. Date and time of the essence. This is the date that we want the owners to get back to us. So we wrote this contract on January 13th. We normally give them 24 hours to respond to our offer. You're going to place your initials right here. The next thing that talks about is the zoning. We need to know how it's zoned. If it's zoned commercial, that's one kind of loan. If it's zoned residential, it's another kind of loan. It could be zoned as a duplex or a multi-unit. This section talks about what is included in the sale. So a permanent fixture could be something like a basketball hoop that is bolted into the cement in the driveway. That would be a permanent fixture. If you have window blinds, those are permanent fixtures. If you have a ceiling fan, that's a permanent fixture. The listing agent will include what appliances are included or if the window treatments are included. So here we see that the garage door opener, the dishwasher, the disposal, the stove, microwave oven, refrigerator, washer and dryer, and window treatments are all included. If there are things that you do not want included, then we would have to list those. If you are getting a loan and it's an FHA or a VA loan, this section will cover your contingency for an appraisal. The home has to appraise for the price that was agreed upon by both parties, and that will go in here. Then you're going to initial here. The next section talks about housing and urban development notices. If you are getting an FHA or a VA loan, you would click this box here saying that you have received that HUD notice. And here talks about the mortgage contingency. So if you're paying cash or you're waiving the mortgage contingency, this box will be clicked. If you are getting a mortgage, this elected box will be checked there. This next section talks about how much your loan amount will be. In this case, this buyer is putting down 5%. It talks about the term of your loan, what type of loan that it is, what the loan to value ratio is not to exceed. In this case, it should not exceed 95% since the buyer is putting down 5%. We do list the mortgage lender that you have decided to use. This lists your interest rate. The second figure is typically about 0.5% above what this interest rate that is listed on your pre-approval letter from the bank. The reason we put about 0.5%, if your interest rate goes up by more than 0.5%, you have the right to back out of the contract and still get your hand money back. The rate should not be more than 95% of what the purchase price is. So this just all talks about what your rights are to terminate if you do not follow the timeline that we give you with regard to applying for your loan. You'll see here that it says you must apply within 7 days. You've already talked to your lender, but they still have to have you submit your initial application. And so that's all that what this is saying is it has to be done within 7 days. As long as you're following the timeline that we give you, you're not going to have a problem if you have to terminate to get your hand money back. This next section talks about the buyer's ability to get insurance. We always recommend that you check with your insurance company and try to get your insurance within 5 days of signing this agreement. The seller will make the required repair. So in the event that the appraiser comes back and says that it needs to have a handrail put in or it needs to have smoke detectors put in, the seller must comply with that. In the event that there's a change in your financial status, you do have the right to terminate the contract and still get your hand money back. The seller represents that it's public water or public sewer. If it were a well, the on-site water would be checked. If it is a septic system, online sewage, or whatever kind of sewage system that it is would be checked here. And this just talks about the Pennsylvania Sewage Facilities Act. You want to read through this, and that's absolutely fine. You don't have to worry about signing anything there. And you're always going to sign at the bottom of each page. In the event that the home is located in the historic preservation area, that has to be stated here. If there are any land use restrictions, that would be checked off stuff here. And then there are notices regarding the land use restrictions, which you can go ahead and read through. The real estate seller disclosure law states that every homeowner that is selling their property within Pennsylvania must complete a 9-page seller disclosure. We'll go through that in a few minutes, but that should be completed. The only time that it doesn't have to be completed is if it is an estate where the children or a family member are selling on behalf of somebody who has passed, and that family member, usually an executor or an executrix of the will, they've never lived in the house. That would be indicated on the seller disclosure. This next section talks about public or private assessments. This typically happens if you're in an HOA neighborhood or a townhouse or a condo where you know that there's an assessment being placed on the seller that they have to pay a certain amount over the next couple of months to perhaps cover the cost of a new roof or a new swimming pool or something like that. The next section talks about a highway occupancy permit, basically giving the Department of Transportation access to a public road if that's in front of or beside or in back of your house. The internet, this essentially says that if a homeowner has any type of recording devices, so a Ring camera or some type of camera inside the home, and that is staying with the property, especially a Ring camera, the owner must remove all of their information from that camera before they leave, and they have to remove themselves from that Ring account so that they are not spy on the buyer coming in. This next section talks about the buyer due diligence period, which is your inspection period. So that's a contingency that's placed on the contract that says that you have so many days to get whatever inspections you need done. The buyer will either elect specific inspections or you will waive those inspections. The first inspection is the home property inspection, and they can check for all sorts of things in this. So typically an inspector should check for electrical, structural, plumbing, those types of issues, but they're going to check everything that they can. You have the right to have a roof inspection, windows, doors, building material, the soffit, fascia, gutters, downspouts, swimming pools, hot tubs. They'll also check for mold if they can. They'll check for asbestos if they can. And depending on how your inspection report comes back, as long as you're within the contingency period, you can still get additional inspections if you feel that those are warranted. You can also get a sewer line inspection, which we always recommend if it's a home that's more than 10, 15 years old, especially in an area where terracotta piping is very prominent. Wood infestation, that means that any wood destroying insect the inspector will check on. So that's termites, carpenter ants, carpenter bees, anything that's wood bearing. You can get that checked. We typically waive the deeds and restrictions unless we know that there is some type of issue going on with that particular property. Water service, typically you're not going to get a water service or a water system inspection if it's public water. Radon, this is totally up to you. I would suggest that you read the U.S. Environmental Protection Agency, EPA, about radon, and the levels should be anywhere but below 4, and if they're above that, then you have a right to ask the seller to install a radon detection system, but keep in mind those are typically over $1,200. So again, you have the right to get the inspection. It's just a matter of what you will do once you get those results. And again, you're going to initial at the bottom of the page. The next inspection is on-lot sewage. So if you are aware that they have a septic tank or a leach bed or whatever, you can elect the on-lot sewage. I always recommend that you initial the property and flood insurance. This just means that you have the right to try to get property and flood insurance on the home that you're purchasing. And in the event that you cannot get that for some reason, you do have a right to terminate the contract. Property boundaries, you have the right to get a survey. Keep in mind that if the property had been sold previously and a survey was done, that survey would be with the deed. And so I would check, with your agent to make sure whether or not you need to get a survey done. And that's a matter of personal preference. Keep in mind that it typically takes about 4 to 8 weeks to get a survey done. And if it's under an acre, it's probably going to cost you about $1,500 to $2,000. Over an acre, it's going to cost you considerably more. Lead-based paint, if it's a house in Pennsylvania that was built prior to 1978, it will have lead-based paint. More than likely, however, the owner has painted over the lead-based paint multiple times since then, but you do have a right to get a lead-based paint inspection. And then if there's any other inspections that you want to get, you can list those here. This is just a notice regarding environmental inspections. You can check for building materials to make sure that they were installed appropriately. You can check for asbestos. You can check for environmental hazards, mold, and any additional information. Here's where you can either call or write these agencies. This next section is your inspection contingency period. This is typically either 15 days or 10 days, depending on what the buyer and the seller agreed to. We'd like to give our buyers 15 days just to give them a little added cushion. Most inspectors can usually book out after 2 or 3 days. So I don't see any problem with 10 days if that's what the seller agrees to. But this whole section just essentially states that you have 15 days to get your inspection done, and then you and your buyer agent will meet to discuss what you would like to be fixed or remedied. And then the buyer agent will type up for you what's known as a BRI, a buyer reply to inspections. And so the inspection has to be done. You need to meet with your agent and you need to draft a buyer reply to inspection and get that to the listing agent within the first 10 or 15 days. After you submit the BRI to the listing agent, the seller then has 5 days to respond, saying that, okay, we will fix these items, but we won't fix those items, and so forth. Then you have 2 more days to decide whether or not you're going to accept what the seller is going to do or not do, or you can terminate, or you can ask for a price reduction. And there's a number of things that you can do here. You can even ask for the seller to give you seller assist. So as long as that's occurring within the 15 plus 5 plus 2 days, you're okay if you terminate and want to get your hand money back. As long as you're following our timeline, you should be okay. If the report reveals that you need to, or the seller needs to expand or replace the on-lot sewage system, so that would be either a leach bed or a septic tank, you've got 5 additional days because it typically takes a while to get a quote from a sewer guy. This next section talks about titles and surveys. The settlement company has to start the process within 7 days. We just typically leave this blank. So they have to start the title search. They have to look for any surveys. They have to make sure that the buyer doesn't have any liens against them, as well as making sure that the seller doesn't have any liens against them. There's no liens against the house. So that whole title section will probably take a good 20 to 25 days to get completed. If the property has oil, gas, and mineral rights, there will be a separate form that you have to sign for that. And the seller will tell us, you'll know before you place the offer whether or not they're retaining those rights or they are conveying those rights to you. This next section is listed not only in your contract, but also on the deed. And it just says that essentially you have surface rights. Anything that's below the surface, you do not have a right to. So if there's coal or anything else underneath the surface, you do not have rights to that. This next section talks about assessments and municipal requirements. An assessment is different from an appraisal. The assessment is what your taxes are based off of. This amount is typically lower than what the purchase price is, and you want that to be lower because the lower it is, the lower your taxes are. So any municipal requirements, the seller is responsible for taking care of. If the property requires an occupancy permit or the property requires a dye test from the municipality, it's the seller's responsibility to get that completed. And if there is anything that needs to be resolved or corrected, the seller has to do that. And this just says that the seller must comply to that. And they have to do it within the time frame that's on the contract. The next section talks about whether or not the property is part of a condominium or a homeowners association. The first section, if it's a condo that you're purchasing, this will be checked. If it's a homeowners association, so if it's a townhouse or a neighborhood that has an HOA, this will be checked. And the reason that is checked is because your lender will need some documents and you will need to know what the rules and regulations are. So it's up to the listing agent to make sure that they're getting this information out to you. This next section talks about more information on the homeowners association or condo association. There are a resale packet that must be supplied to you and the lender within so many days. If it's not an HOA, you don't need to worry about any of that. Section 17 talks about real estate taxes and the assessed values. The assessed value is done by the school district and the municipalities, and you have a right to appeal the assessed value once you purchase the property. But we always tell our buyers, expect your real estate taxes to go up. If the home sold higher than what it sold the last time, your assessed value is going to increase. Just letting you know that, look, your real estate taxes are more than likely going to increase. Maintenance and risk of loss. Section 18 talks about the fact that the seller must maintain the property. So that means any fixtures, any landscaping, any appliances, anything that they're conveying to you must be conveyed in the same manner when you first place the offer. This whole section talks about that. Home warranties, you have the right to get a home warranty on the property that will cover you for 365 days after closing. It typically covers core systems, your HVAC system, your water heater, your appliances, so your refrigerator, stove, washer, dryer. We can order the home warranty for you. We like to have it paid by the seller, but if the seller's not paying, then you have a right to get that as well. And you can actually renew that every year. It's a $100 deductible, and if they cannot fix it, they have to replace the item. The recording, this talks about where the deed will be recorded. Assignment, this just essentially says that the agreement is a binding agreement between all parties. You cannot assign that contract to anybody else. The next section is the governing law and the jurisdiction. If anything arises from this, it will be done or governed in accordance with the laws of Pennsylvania. Foreign investments, if you're a foreign investor, that has to be disclosed. We typically don't see anything in this whole section. Notice regarding convicted sex offenders, they are actually protected in Pennsylvania, and we always recommend that you do your own due diligence to see if there's any sex offenders living in that area. So we always encourage you to contact the local police or the state police. So the representations basically states that as your buyer agent or as a selling agent, we are representing the property to the best of our knowledge, and nothing can be changed or altered or amended in this agreement unless it's in writing by all of the parties. The buyer has the right to inspect the property and any fixtures that are on the property, and they have to stay in their present condition. In the event that you terminate, you have right to get your hand money deposit back, but only if you are following our timeline that we give you from the very, very beginning. So we stay in touch with you the entire way throughout the process so that we know and we can make sure that you are meeting all of your obligations with regard to the timing. If we get to a situation where you have terminated and the seller does not agree with you getting your hand money back, the contract states that they have 180 days to dispute that, but we always put in here 1 day. Most of the time, the listing agent catches that and asks for at least 10 to 30 days. But all this means is if the seller is going to come after you for the hand money, they only have 1 day to do that. If the seller does come after you because you've terminated, they only have the rights to whatever your deposit was. So if your deposit was $3,000, they only have the right to get $3,000. Mediation, in the event that there are any disputes, you agree to go through a mediation process. The release talks about the fact that you release our brokerage, myself, any employees of the brokerage from being liable for any claims or losses or damages that you have experienced on this property. The real estate recovery fund just essentially says that you can be reimbursed if you feel that you need to file a civil judgment against your real estate agent. The communication with the buyer and the seller, essentially any communications with you has to go through your buyer agent, and the same works on the other side. The owner must go through their listing agent for any communication. Essentially, it's only the two agents that are talking to each other the entire time. So you cannot go and talk to the seller, and the seller cannot go and talk to you directly. In this last section section just talks about anything that we're adding to the agreement. So if you're trying to sell your property, there will be a contingency agreement there. The appraisal contingency. This just states that the house must appraise for what you're purchasing it for. If there's a price escalation addendum, that would appear here. So we just have to check off in this section any other addendums that we have to put on here so that the listing agent and the seller know that they've got to check more than just the first 14 pages. We always want our buyers to get a home warranty, which we talked about earlier. And this is just saying that the seller is going to agree to pay that warranty. This is just where you're going to start signing at the bottom of the contract. But this first section says that you've received the consumer notice. You would have received that from us from the very beginning. You have received the estimated closing costs from your lender, or if you're paying cash, you would receive a estimated closing cost from us. If the home was built before 78, you've received that lead-based paint hazard disclosure form. And all you're going to do is sign here and date. There's 2 of you or 3 of you. You're all going to sign and date. And this is just the signature and date of the homeowner. This next document is the appraisal contingency, which just talked about it saying that the appraiser must appraise it at either the value that you're purchasing at or higher in order for you to be able to get a loan. If the appraiser feels that it is not worth that much, then that's another discussion we have to have once we get to that phase. These next 9 pages I'm not going to go over. This is your seller disclosure statement. This must be completed by every homeowner in Pennsylvania once they're selling the house. This just talks about the people who own the property, how long they owned it, what the age of the property is, and then this just talks about just different aspects of the property, and if they know that there were issues, they must disclose it on this seller disclosure. That does not mean that every property owner fills this out completely or correctly, so I would make sure that you're going through this with your agent to see what's going on with the property. Every once in a while, you're going to see that they write things in here, and you always want to pay attention to what's written in here because it's usually pretty important. This says that they did get a sump pump in the basement, and since then they have had no water issues in the basement. If they've ever gotten permits or done any alterations to the home, that should be included there. This talks about, if it's public water or if it's a well, and that just goes on and on about the water. This talks about the sewage system, and it just goes on and on. So not every section will be filled out, but for the most part, they should try to fill out as much as possible. It talks about your water heating system, your air conditioning system, your heating system, the age, the electrical system, if the seller knows, any other equipment that's included in the sale. Again, you can read through. Every one of these is going to be different. You're never going to see 2 of these that are exactly alike. Just going to initial the top of every page, and then you're also going to initial the top of page 9, but then you're also going to sign the bottom of page 9 as well. The next document is the lead-based paint disclosure form. In the event that the seller is aware that there is lead-based paint in the house, they must disclose that. So typically you'll see their initials on the second line, and then both agents have to sign it because we have to make sure that we're disclosing anything about lead-based paint that we know. We'll also give you a pamphlet that says protect your family from lead in your home, and I think it's about a 35-page document that you can read. And this is just saying that the buyer has waived the opportunity to conduct a risk assessment on whether or not there's lead-based paint. The sellers sign, the seller's agent signs, and then the buyer signs, and then their agent signs. These next few forms are just for RE/MAX Select Realty. This is just saying that you are going to use the settlement company KeyMax Settlement Services. If you have your own settlement company that you want to use, you can certainly do so. We just suggest KeyMax because they have processes that we follow. They know how we work. They always close our deals for us on time, and that's most important. And their rates are very, very competitive. So this is just saying that you're going to go ahead and elect them. Every brokerage is required to disclose whether or not they have an affiliated business arrangement for anybody else that you might be working with throughout the process. In this case, KeyMax is an affiliate of RE/MAX, and you have the right to choose whatever settlement company you want. They're the company that's going to check for liens, to check for a clean title, all of that stuff. You might be using our mortgage company. You might be using our home warranty company. Again, this is just saying that RE/MAX and any other brokerage that you're going to go to, we have to disclose if there are affiliates that you're working with. And this is just your agent's name, and this is the property address address, and then you've got to add your name and phone number and email address to there. The exclusive buyer agency contract, the new law after August 17th of 2024, says that you must sign this the first time that you go and tour with your agent. This is just the agent's information, and then this is where your information will go as the buyer. This just says, do you have a written agreement with any other brokerage? If you're working with us, you'll say no. This says when this agreement will start. So this just means that we started working with this client in December of 24, and the contract goes for a year. If the seller is not paying our minimums, the buyer, you are required to pay the difference between what the seller pays and what our minimum is. So if you remember at the top of this contract, the seller said that they would pay 2.75%. You would be responsible for the 1.25% of the purchase price, or $3,500, whichever is. This next section talks about a broker's fee. Most brokerages in Pennsylvania charge a broker's fee. Ours is $750, which is listed up here. And that's spelled out in this agreement. We cannot ask you to pay higher than what that brokerage fee is that we have listed here. Dual agency, again, you would have seen this on the consumer notice. You saw it in the contract. This next section talks about our services as the brokerage to you. We cannot take any action that's inconsistent with what your interests are. Throughout this whole process, we are making sure that we know what your financial services are, what your settlement company services are, your title transfer, insurance costs, your repair costs. We try to stay on top of all of that for you throughout the entire process. The entire contract is between the broker and the buyer. Even though my name is on it, I'm actually an independent consultant with the brokerage. So the contract is actually between the buyer and the brokerage that I work for. You cannot transfer this contract to another broker. Confidentiality just means that everything that you tell me will not be shared with the other agent nor the seller. The expertise of real estate agents, we're all licensed by the Commonwealth of Pennsylvania, and we're obligated to disclose any adverse factors about the property. Deposit money, the broker is going to keep this money in a non-interest bearing escrow account until closing. The Civil Rights Acts, this section just talks about the fact that we will not discriminate against race, color, religion, sex, disability, familial status, your age, your national origin. No disregarding convicted sex offenders. We always recommend that buyers contact the local municipality police department or the Pennsylvania State Police if they are concerned about the presence of sex offenders in the area. Section 13 talks about buyer inspections, in that you have a right to get inspections, and then the seller has to agree to that. Recordings on the property. The seller must tell us if they are recording on the property. You are not allowed to record unless all the parties know that they're being recorded. Buyer releases the broker and me and any employees or officers of the firm from any liability from any claims or lawsuits or actions which may arise. Recovery fund, we talked about this before. Pennsylvania Real Estate Recovery Fund will repay any person who received a final court ruling or a civil judgment against a licensee. And then the last couple bullets are, you've read and received the consumer notice. You've read the entire contract before you signed. And this just talks about a couple more things that you can read through. And then all you have to do is sign the bottom and date it. I also sign and date on behalf of RE/MAX Select Realty. And this is the consumer notice, which is not a contract. You would have received this along with the buyer agency contract. And again, Pennsylvania just wants you to know that there are different types of agency relationships. The first one is the listing agent or the seller agent, where they represent the interests of the seller. The buyer agent is what we're doing here. We represent your interests. In the event that you are purchasing the property that we have listed, we can act as a dual agent, meaning that we represent both you and the seller. If you are uncomfortable with that, you can ask us to designate an agent in your office to either represent you or the seller. And then this just talks about all of our responsibilities to you as your agent. So you can go ahead and read through all of these. You just simply print your name and sign the bottom. The last thing I wanted to show you was the cost estimate. This is for a cash deal, so it's not going to be as detailed for somebody that needs a mortgage. But this this is a form that just shows you everything that's going to be paid throughout the process. It'll show in here what you'll need to bring to closing, all the different costs that are associated. So you've got transfer taxes, you've got settlement company fees. And again, if you are getting a mortgage, you're going to have all the mortgage company fees as well. And that is it. If you have any questions, please feel free to give us a call, and we're happy to walk you through anything that you need clarification on.